Well, it goes on here, and then there's an Article 2, and it talks about, down here at the bottom of page 17, where it says Article 2, it tells us about our president, and it tells us about the executive power of government, and it kind of goes on there. And then you get up here to Article 3. Here's a real interesting Article 3 here. I'm going to show you something here to blow your mind. I was reading through here the other day, and remember now in this other lesson, let's see now, we did the lesson here on service of process, and I showed you a thing called an information, didn't I? And we had this information, and I've got to stop here for a moment. I've got to explain this little story to you. This is just blew me away. I think it blew the judge away. I was in court the other day. They charged me with a felony. They said that I stole some traffic tickets out of the traffic court. And this particular judge is a real funny fellow. He's just a real fine man. He's just funny. And we got into the court, and he said, Mr. Gordon, you've been charged here in this information with a violation of Idaho Code 18-2403 and 2407. And I have this information in front of me, and he handed this information. I'd never seen this thing in my life. He handed it to the bailiff, and this lady brought it over to me, put it down in front of me, and I was looking along here, and it says at the top of the page, in the District Court of the 4th Judicial District of the State of Idaho. And I read along there, and he said, now, Mr. Gordon, would you waive the reading of the information? Now, remember, I've told you, and it's my custom, I demand all of my rights at all times, and I don't waive any of my rights at any time. So I said, Your Honor, if it please the court, I have never seen this information until this moment in time, and I haven't read it. I don't know what it says. I don't know what it means. And I'd like you, if it wouldn't be too much trouble, to go ahead and read through it with me. And he started up at the top in the District Court of the 4th Judicial District, and he finished with the words, all of which is against the force and the dignity and the laws of the state of Idaho. And he stopped, and he said, Mr. Gordon, do you understand the charges against you? And I paused for a moment, and I said, no, Your Honor, I don't understand the charges in this information, and I think I've got a question or two, and maybe if I could get some answers, maybe I help me understand this. Here's my public official, my public servant. I hired this guy, and I pay him, and he sits up there on that bench, and, you know, I want him to perform for me. I don't want to waive my right to reading this. And I said, Your Honor, do I understand that the party of interest is the state of Idaho? Yes, Mr. Gordon. All informations in the state of Idaho are made out in the name of the state of Idaho versus George Gordon, or state of Idaho versus Sam Smedley. They are? Goodness sakes, Judge. Wait a minute. I don't think this court has jurisdiction in this matter. There's something wrong here. Now let me see. Yes. It's here in the Constitution of the United States, on page 21, Your Honor, where it says, and I want you to follow along with me, in all cases, and I'm going to skip over this, affecting ambassadors, this is a clause. It says, in all cases, and then flip over to page 22, in which a state shall be a party, the Supreme Court shall have original jurisdiction. The courtroom just fell into stony silence. Somebody had walked into the courtroom and said, wait a minute, the contract says that you're going to deliver the stuff on the 24th. Now, why isn't it delivered on the 24th? Beginning to see the difference between a man that walks into the courtroom and says, we made an agreement. And what the hell is that on that truck? I told you to bring alfalfa. What is this grass hay you're bringing me? That's called being the belligerent claimant in person. You bet I'm a belligerent claimant, hauled into one of my own courts by my own public servants. A guy that picks cotton out in the field and then hauls me, the master, in and says, we're going to prosecute you by information. He said, this court doesn't have jurisdiction in this matter. The court of original jurisdiction is the Supreme Court in Washington, D.C. Unless, of course, we have a grand jury indictment. Now, I don't know what we're doing here, Judge. I thought we were coming here to a grand jury indictment today, and all of a sudden I find out that I've got a prosecutor over here, some prosecuting attorney. I don't understand this. You're asking me if I understand this. Well, now let me ask you this, Judge. Let me see if I'm correct in my assertion or my presumption that this information is illegal and unlawful. And I want you to follow along here because I'm going to send this little... I think I told you I was going to put this little quotation in the last lesson. If I didn't, I'll put it in here. Most important quotation on informations I've ever seen in my life. And the case in this from the Supreme Court is called Makin, M-A-K-I-N versus United States, 117 U.S. 348. That case we just discovered about a week or 10 days ago. Well, I shouldn't say that. So it might have been 30 days ago. I don't know exactly. But that's the most important case I think I have seen on the subject matter of complaints, informations, and grand jury indictments. Let me read this to you. Blow you right out of the saddle. Follow along with me here. It's this came from this Irwin Schiff book, and it's called Makin versus U.S. An information is a written accusation of a crime made by a U.S. attorney which permits, for crying out loud, which permits. What do you do when you permit somebody to do something? I'm going to permit you to eat this popcorn in the front room tonight. That's an exception to or permission from somebody who has authority to grant you to do something. And so, my kiddo, thank you, Daddy, for letting us eat popcorn. And so what do? You walk in the court, oh, yes, I'll give you permission to prosecute me with this information, and I don't need a grand jury. Which permits the government to prosecute an individual without benefit of a grand jury indictment. Would you underline that? It permits the government to prosecute you without a grand jury indictment. Well, isn't that interesting? Did you want to waive your benefit of a grand jury indictment? Did you want the government to prosecute you, or did you want your fellow citizens to prosecute you? You see equity and the common law? Under the common law, you have a right to a grand jury, but in equity, you grant permission with a contractual agreement. So here's your information coming into the courtroom, and with this information, you're granting this permit or this permission to do something that they otherwise don't have the power to do. I walk into the courtroom. Now, this particular judge is evidently he's a constitutionalist. He kind of grinned from ear to ear and looked over at the prosecuting attorney as if to say, what the hell are you going to do with this guy? Now that you've got him, what are you going to do with him? Going on, it says, an indictment was required in my case because I was charged with an infamous crime. I'm going to stop with the word infamous crime. Underline infamous crime, and then take your Constitution here, your master contract. Let's turn over to the Fifth Amendment, shall we? I know what I need now is a dictionary so that I can look at the word infamous crime. And we'll take a look at this dictionary definition here in a moment. But let's just, for the moment here, let's take a look at our contract and find out what this guy's trying to put over on us. We got a truck sitting out here in the yard. It's 6 days late. The bill's $14,000. It doesn't have alfalfa hay on it. And here's Article 5. It says, no person shall be held to answer for a capital or otherwise infamous crime. Now, in your Constitution booklet, would you underline the word infamous crime? There it is, infamous crime. Now we sit here and we say, gosh, I wonder what an infamous crime is. I don't know. I've got the foggiest notion. I went to the government schools, and never once in the entire time I was there did anybody ever say an infamous crime is. An infamous crime, friends, is a felony. And when you look in Bouvier's Law Dictionary, you're going to find that infamous crime is a felony. Now, I looked on the front page, upper right-hand corner, and on my information it said felony, information of a felony. And I'm sitting here saying, well, what is this? I have this infamous crime. I'm charged with a felony by information. It's entitled the State of Idaho as the party. Now come back to the quotation, shall we? Are you starting to get suspicious that maybe our government officials have in some way failed to live up to the terms and conditions of the contract? Or maybe they're just trying to use fraud and deceit to do something to us that we otherwise would not allow them to do. That would be my observation. Going on, it says, the Supreme Court had clearly ruled in Macon versus United States, 117 U.S. 348, that any crime for which the punishment is imprisonment is an infamous crime. Friends, what is the definition of an infamous crime? Well, now, it looks like to me, if the Supreme Court of the United States has any authority on the subject, that an infamous crime then is a crime for which imprisonment then would be the result of the court's decision or the court's sentence. Could even be a felony, couldn't it? I mean, a misdemeanor, couldn't it? The use of informations has a long history. Gosh, that's interesting. Did you know that? I didn't know that. Let's go through and see who said so. For example, in the reign of Henry VII, writes Justice Blackstone. Blackstone? Who's Justice Blackstone? Could he be an authority on law? Yeah, he's probably the number one authority in law. If he's not number one, he's certainly around number 2, 3, or 4. And he says, a very oppressive use was made of them for something more than a century, so as to continually harass the subject and shamefully enrich the crown. Is that happening in Illinois? Is that happening in Texas or Maine? Are they shamefully enriching the crown by the use of informations and getting people's permission, that is, permits the government to prosecute an individual without benefit of a grand jury? They do that in Idaho. I think I told you before, we haven't had any grand juries in this state in 18 years. I'll tell you why in just a minute. And shamefully enrich the crown. Also, as the court observed in People versus Spoonsler, and there's the citation, the oppressive use of this mode of prosecution by information occasioned struggles to procure a declaration of its illegality. My goodness sakes. You mean to tell me our government public servants are out here breaking the law, prosecuting us with informations which were designed to harass the subject and shamefully enrich the crown, and that they have been outlawed? In short, prosecutions by informations have long been a means of political suppression and intimidation. Are your government officials harassing and politically suppressing and intimidating you, friends, in violation of the master contract that you wrote with your government officials? Well, they're doing that here in Idaho. And so, to go on with the story, now this is an interesting judge, and he's a heck of a nice guy, and I want you to understand that not all judges are bad. In fact, we don't know of any real bad judges. There's just 2 or 3 that we know of that are kind of ignorant. And so, the judge goes on, and he kind of snickers and chuckles a little bit. And I said, in addition to that, Your Honor, I want to demand all of my rights at all times. And I waive none of my rights at any time for any cause or reason. And he kind of grinned a little bit. And yeah, here's old Gordon coming into the courtroom demanding all of his rights. And here he is bringing up the master contract. You know, how many times have you ever walked into the courtroom and watched somebody say, Your Honor, who's the party of interest? Your Honor, where's the grand jury? Your Honor, why are we prosecuting people shamefully enriching the crown with information instead of prosecuting people in the name of the people of the state of Illinois? And why don't we have a grand jury to determine whether or not this person's guilty of a crime? You ever seen that done? Well, that's what I tell people to do, and they go into the courts, and I'm telling you, mouths just drop open. Like, what is this? Lawyers, just sit there and they just shake their heads. I can't believe that this guy's doing this. Now, I promised you that we would look up this thing called infamous crime. This is Bovier's Law Dictionary, okay? I want you to take a close-up of this, would you? This Bovier's Law Dictionary was made in 1870. It cost $12 in 1870. Today it costs $150. The price hasn't changed at all. 12 silver dollars. 12 silver dollars, and it's still the same price. Which just goes to illustrate Article 1, Section 10. The value of money is this. All of the gold and silver in the world equals all of the goods and services in the world at any given time. All the gold and silver in the world in 1810 represented all the goods and services of 1810, and all the gold and silver in the world today equals all the goods and services of today. And so if you'll just turn with me here, I believe it's on page Infamous Crime. Yeah, on page 704. An infamous crime is a crime which works infamy in one who has committed it. Now, when we go from infamous crime, or infamous, let's go over to felon. That's F-E-L-O-N on page 578. And listen to these words. A felon is one who is convicted and sentenced for a felony. A felon is infamous and cannot fill any office or become a witness in any case. Oh, now we're starting to get somewhere. Our founding fathers understood definitions of words. And so here when they wrote the Fifth Amendment to our federal Constitution, they said, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. How then is your government able to prosecute people through informations? Go back over here now to this information. What is it? An information is a written accusation of a crime made by a U.S. attorney which permits the government to prosecute an individual without benefit of a grand jury indictment. You have to permit them to do it. Failure to object timely is fatal. Failure to assert your rights waives your rights. And so here's all of our people going to school in these crummy government schools. And are those government schools teaching these people about grand juries and about their constitutional rights and how to use those rights and how the decision as to whether to move forward with an information complaint or a grand jury is a choice that needs to be made and that demands have to be made upon the court? Well, it never occurred when I went to school, and I've got a couple of kids that are in school now, and I keep asking them every once in a while, do you ever hear anything like that over there in the high school? Never heard a word yet. Got a boy 15 and a girl 13, they haven't heard a word. We'll just keep waiting and see if they're going to say anything about these informations. Well, to get back to the story now, you see this judge, and I won't mention his name, but he's a heck of a nice guy, and he's a very knowledgeable fellow, I think, in constitutional law. He's sitting up there kind of snickering and grinning a little bit. And so I went on, and I kind of got a little heavy, and I said, and I demand all of my rights, including my rights to the grand jury. And another thing I contend for, Your Honor, and that is this thing of ex parte hearings. I hadn't been notified that there was a hearing today on this arraignment. The last I heard was that Judge so-and-so was going to bind me over. And I heard word on the street that I was going to be arraigned today in the district court. Now, I hadn't had any service of process, and I complained about the service of process and objected to the courts holding ex parte hearings, and I went on to eloquently say and reiterate, what if I hadn't heard this rumor on the street that this arraignment was going on today? Well, I might have failed to show up today, and the court may have revoked my bail and put a warrant out for my arrest. And the judge leaned over and he said, I don't think this court would do that in this case, Mr. Gordon. And he chuckled a little bit because I've heard word here that in Idaho they wouldn't, some judge told me that there isn't a judge in the state that would put bail on me. That's not true. I had one set bail for $5,000 on me the other day. I don't think she liked me at all. And so we went on to another subject matter, and I said, Your Honor, I demand a grand jury. This is an infamous crime under the Fifth Amendment and under Idaho Code 1911-01 and under Rule 6 of the Idaho Rules of Criminal Procedure. And I face 40 years in the penitentiary and a $20,000 fine. And he said, excuse me, Mr. Gordon, you do err. No, you've misread the statutes, Mr. Gordon. You've assumed that you're being tried for, how do you word that now, extortion. But Mr. Gordon, you're not being tried for extortion. If you look at this information, it says plainly, felony grand theft. Yes, you're being charged, Mr. Gordon, with felony grand theft. That is, the 2 traffic tickets that you allegedly stole are worth in excess of $150. And you don't face 40 years in the penitentiary, Mr. Gordon. You only face 28 years in the penitentiary. And we all started laughing, except this prosecutor over here. The prosecutor, he didn't think that was funny at all, and I was giggling and chuckling. And I couldn't miss my lines, and so I replied, well, thank goodness, Your Honor. I'm really happy to know that I'm only facing 28 years in the penitentiary, and it's not 40. And he leaned over and he said, I thought you'd be gratified to know that, Mr. Gordon. And the fine is only $10,000, not 20. And he leaned back and he grinned a little bit. You may proceed, Mr. Gordon. And so I went ahead and I proceeded. And we got down toward the end of the arraignment. And I said, well, Your Honor, I move for dismissal for all of these reasons. And there was 9 causes here that I had gone through. And I brought up the subject of the prosecuting attorney, and I said, who is this man sitting over here to my left? I know his name, and I've seen him in the courthouse, and I believe that he's an employee of the prosecuting attorney's office. But he's sitting in this courtroom illegally and unlawfully, Your Honor. This man is a judicial officer under our state constitution, Article 5. And under Article 2, Article 5, and Article 18 of the Constitution of the State of Idaho, a public prosecutor has no capacity to prosecute a case in a courtroom. As a matter of fact, Your Honor, he's specifically precluded from the courtroom because in this state we don't have any public prosecutors. He is not a public prosecutor. He's a judicial officer, and this court's improperly set. We've got 2 judicial officers in here, you and him. And I demand my rights to be prosecuted under the executive branch of government, which in our federal constitution is Article 2, remember? And the judge sat back and he just kind of looked over at Mr. Won't mention his name either, he's kind of a hostile fellow, and he said that Prosecutor Jones over there. And Prosecutor Jones got up and said, well, Your Honor, Mr. Gordon hasn't filed any motions pursuant to the rules, Your Honor, and so I'd move at this time that you bind Mr. Gordon over and plead not guilty for him, and let's set this thing for trial today, and let's get to moving on it. And he stuttered and stammered around a little bit, and the judge looked over at me. Well, now, Your Honor, I'm very sorry, I replied, that I haven't responded in writing to this information, but that young lady just gave it to me about 3 or 4 minutes ago, and I just haven't had time to respond in writing, Your Honor. And that's why I'm making these oral motions. And these 9 oral motions pursuant to this information are just what I'm thinking about off the top of my head. It isn't really what I may be filing on. And the judge said, well, I agree with you, Mr. Gordon. I don't think Mr. Jones, I don't think he's had time to respond yet. See how the judge sits back with his neutral hat on, just kind of watching the ball go back and forth. And this is exactly what judges are supposed to do. They're just there to watch the ball. When the ball goes back and forth and it finally hits the net, he makes a ruling. Point. That's what the judge is there for. And this judge is just doing that. He's just having a good time. So we went on to the next step. Well, Mr. Gordon, how long is it going to take you to file this? Well, Your Honor, it depends upon the terms and conditions of the contract. And, of course, I always pull this out. I always refer to it as the contract. I see some pretty serious breaches of the contract here, Your Honor. The judge understood the term contract perfectly. Well, Mr. Gordon, why don't you write up your complaints, and why don't you tell me why you won't pay this guy $14,000 for that load of hay? And why don't you illustrate where's the contract? And I'm going to bring in the contract into court, and I'm going to say, now, this guy is prosecuting me. Do you see what I do? I don't go in there, like a constitutional nut and jump up and down. What you do is you write motions based upon the contract. What specific thing is wrong with this particular case? The word infamous crime, information, and did you notice that I've got authorities and citations? I've got Justice Blackstone, Macon versus U.S., People versus Spoonsler, Fifth Amendment. And then in our own state, Title 19, Section 1101. Those are the things that I'm going into the court arguing. You know why many of our patriots nationwide are looked upon as kooks? They walk into the courtroom really not understanding their contract. The first problem is, many people look at this and they read it and they don't understand the English language and they don't know how it works. And they don't know how the wording is. Now, the way to find out how the Supreme Court is going to word or construe the wording of the contract is this. Every section in this little book has been ruled upon by the Federal Supreme Court at some time in history. Sometime between 1787 and today, this word infamous crime has been talked about. So you walk in, and there's a book in there, or a set of books, rather, that's called Words and Phrases. Remember that term. Write it down right now. Words and Phrases. It's a blue volume. There's 15, 20 volumes to it. Go look up the word infamous crime. Infamous. To illustrate, I haven't looked up the word infamous crime, but I had to do a motion and brief on the subject of Social Security, and what I wanted to know was, has the Social Security system ever been taken into the Supreme Court of the United States? And if so, has the question of the involuntary contributions made by employees ever been ruled upon? So I went to Words and Phrases and looked up Social Security, and I just counted the citations. There was 132 times that the United States Supreme Court's ruled on that. 128 of those times were all kinds of subject matter, and the 4 cases that were the closest to the subject that I was looking for were ruled upon. In fact, 2 of them in 1935 and 36, and then another one in 1940, and then another one in 1959. And those were the 4 that were relevant to the subject matter. Now remember, I told you that I don't care whether or not you agree with those 9 judges in the Supreme Court in Washington, because remember, we're not here to argue about whether or not their decisions are right or wrong. Those are political and moral decisions or distinctions that you may or may not agree. We had a man in here not long ago, and he said, I just absolutely disagree with the Supreme Court in Miranda versus Arizona. I think they're all wet. And you can't very well turn against the guy and say, well, I agree with Miranda, and I think it's right, and I think it's good law. I don't know. There were 4 justices that agreed with this fellow. The case came down 5-4. What I want to illustrate is that whether we like it or not, that's the law of the land. When you get a judgment against you or for you, it's going to be based upon what those justices say is the law, not upon what you think it ought to be. And there's a lot of people out there in TV or radio land that say that the 16th Amendment is unconstitutional. And I'm not going to sit here and say it is or it isn't, that it's good or it's bad. I don't know. And I'm not even going to get into that philosophy or philosophical argument. But I do know this. The Supreme Court of the United States has ruled on the constitutionality of the 16th Amendment, and they say it's constitutional. Therefore, it is the law of the land. And if you get caught violating the terms and provisions of the 16th Amendment, you will go to jail, you will not pass go, and you will not collect $200. Now, some guy told me the other day, said, Gordon, you're a traitor. Why, you're just sitting here preaching the same old government routine and lawlessness that our government's oppressing us with. And I said, baloney. I'm telling people when they come in and talk to me that if they're tax evaders, they better stop evading the tax. You know, I'm not going to sit here and argue with people about whether or not they're tax protesters or tax evaders or tax patriots or anything else. I don't know what all those words and terms mean. You can decide for yourself. What you've got to understand is that if you want to be successful in the courts and if you want to win in there successfully, and I contend that I'm a consistent winner in the courtroom, is to quit philosophizing about abortion and recognize the law. If you don't like the law, then you have to go change it in the legislature. There's your hope for salvation. But other than that, I'm not out beating my tom-tom trying to get laws changed. What I want to do is to go into the courtroom and secure my rights based upon the laws that's already established. And I think I've said earlier, I don't pay any income tax. I don't file 1040 forms. I'm not subject to Title 26 because I don't have any income. Now, if you have income, you're going to have to pay the income tax. And the High Court has said numerous times, there's nothing wrong with a man so arranging his affairs so as to minimize his tax liability. There's nothing wrong with you living up to the terms and conditions of this contract and then doing so in a way that you don't have any tax liability. Nothing wrong with that. But there's something really wrong with violating the terms and conditions of the master contract and then trying to claim, well, that doesn't apply, because that's the fellow who comes in with a load of hay and he uses this argument. Well, it's hay, isn't it? And it's close to $10,000, isn't it? And it's just got a little bit of mold on it, doesn't it? No, that doesn't hack it, friend. That isn't the terms and conditions of the contract. And when you get in the courtroom, there's so many people, you know, that run around. First of all, they've got credit cards and they've got bank accounts, and they're converting their labor, which isn't income, into income by giving up title to their checks and depositing it in the bank. And then they turn around and say, well, I'm being tricked and fooled, you know. Yeah, that's true. Now, there you've really got it. Now, you might argue fraud. You might say that these people in the courts and these people in the banks and these people who are the lawyers and prosecutors and these tax collectors are defrauding us, and that they're doing things that are outside the scope and the protections or the duties or the restrictions of the Constitution, depending on how it's applied. Now, let me tell you another story here, because, you know, sometimes stories kind of help to illustrate and to help us understand what it is that our problems are. And when we're talking about this thing called the separation of powers and the limitation on powers and where the power belongs and who's really got it and how to exercise it, we sometimes have to go through the school of hard knocks, and we have to do a little trial and error to find out how it works. Now, while I was in this court the other day working on this felony, the judge asked me this question. Now, I want you to answer this question just like you would normally answer it if it were asked of you. The judge said of me, Mr. Gordon, do you read and write the English language? Mr. Gordon, do you understand the English language? And, Mr. Gordon, do you understand the charges? If those three questions were asked of you, how would you answer those three questions? Take a couple seconds. Take a piece of paper out so that you don't fudge your cheek. Here's your three questions again. Mr. Gordon, do you read and write the English language? Mr. Gordon, do you understand the English language? And Mr. Gordon, do you understand the charges against you as related to you in this information? Or do you understand the charges? In my case, I answered the questions no, no, no. Now, am I communicating with you in the English language right now? Let me show you one of the most powerful tools or weapons that are used against you and used against me when we go into the courtroom. And it's called admissions and confessions. Remember that? Now, one of the things that you need to learn right away is when somebody asks you a question, you have to say, well, now, what does that mean to me? And what is it that he's trying to get me to say that would be damaging to me? Now, it sounds pretty innocuous to ask a person, do you read and write the English language? All right. I went on to say, and he questioned me about that, and he said, Mr. Gordon, I find it difficult to believe that you don't read and write the English language. And I said, well, Your Honor, I have a very rudimentary understanding of the writing and the reading of the English language and a very rudimentary capacity to speak and to understand the English language. And he said, well, I'm going to construe those answers as, yes, you understand the English language. When I go back with the motion hearing, I'm going to write a long treatise on the subject matter of the English language. Now, follow along with me here because I'm going to show you something. Probably every one of you answered the question, well, yes, I can read and write the English language, yes, I understand the English language, and yes, I understand the charges, because, you know, they're laid out and you can read and write and spell, and you went to public school, didn't you? First of all, how many words are there in the English language? Let's break it down and see if we can determine some facts before we make an answer. I have a dictionary at home that was printed in 1912, and it claims to be a complete and unabridged dictionary of the English language. It's about that thick. Let's see if I can get this on the TV screen. It's all of 3 to 4 inches thick. I mean, it is as thick as... It's as thick as those 2 volumes or thicker. In fact, it might even be thicker. And it's much bigger than an ordinary book. It's as big as this file folder. It may not be as tall, but it is certainly wider. I mean, it's a big book. And I don't have the size of it, but it says up in the flyleaf that there are 512,000 words in that volume. It's written in India paper, like this Bible. I have a Bible here. Happens to be on my desk. This is the India type paper. That's that real thin type of paper. 512,000 inches. The other day I was reading a newspaper, and there's a column in there called Lou Boyd. And you may have seen the Lou Boyd column in your newspaper in your town. And it said in one of those little questions and answers that there was 428,000 words in the English language. Maybe a lot of archaic words have been dropped out between 1912 and the present. Or maybe there's some other book or dictionary, and maybe there's 2 or 3 different types. I don't know. Let's assume that Boyd is correct and that there's less than 428,000. Let's assume there's just an even 400,000. The same Lou Boyd said that, ask yourself this question, well, how many words does the average citizen have in his vocabulary? And the answer, Lou Boyd said, was 6 to 10,000 if he's a high school graduate. If he's a college graduate who has specialized in some of the professions or in language or English, it could be as high as 20,000. I thought about that for a moment, and I said, that's interesting.